So my name is Stacy Haney. I understand the introductions were done earlier, so I'm going to jump right in. Just real quick, my name's Stacy. I'm a school board attorney. Like Brad, who spoke before me, represent a number of school divisions all around the state. And one of my favorite things to do, honestly, is to get to help people like you guys solve problems and help you get the legal issues out of the way so you can get back to helping our students be successful. So my topic today is student discipline. And I've got a little over an hour to fill talking about student discipline. And I could talk nonstop for an hour, 2 hours, probably longer, about student discipline, but that would be really boring. So what I'd like is if you guys have questions, please feel free to ask them. Don't feel like you need to wait until the end, because I'll talk right up until the end. But if you have a question, hopefully pertinent to whatever slide we're talking about, please feel free to raise your hand and ask your question, because that'll make it more interesting, hopefully, for everyone. All right, so with that said, our agenda for the time that we have together today, it's going to be all about discipline, but I'm going to try to cover a handful of topics. First, and probably the bulk of our time, is going to be on the student discipline process, so just the legal process, the legal requirements for discipline. Then we're going to talk about some practical tips. Hopefully it's all practical, but we're going to spend a section talking about really the practical tips on what you as a principal should do before your discipline hearings, during your discipline hearings, and after your discipline hearings to just get a little bit better result, maybe reduce your legal liability, maybe just have the hearing come off a little smoother. So some tips. Then the third thing we're going to cover towards the end is some specific discipline procedures for students with disabilities. And then as a bonus topic, if we have time, I'll talk for a couple of minutes about searches. If we don't have time, there's some information in the slides you can read. But that's kind of the sequence we're going to cover today. So if you have a question about special ed, maybe save it till we get to special ed, vice versa. Okay, so first, the student discipline process. And what we're going to talk about for the next bit of time is going to be the process for general education students and for students with disabilities after you've conducted your MDR and found that it's not a manifestation. So this is the general process. I have a caveat to everything I'm about to tell you is check your local policy and make sure you're following your local policy. And if you go back and you check your local policy and it's vastly different from what I tell you here today, then maybe say something to somebody like, hey, I went to this conference, there's this amazing speaker, so we might just want to check with legal counsel to make sure our process is right. But there's definitely some places where, it's kind of like a choose your own adventure book. The law sets forth a process, and some things have to be done by the school board. Some things are done by the school board unless the school board delegates it to the superintendent, et cetera. So there's several different ways that the process can go under the law, and your policy is where your school board has set forward. They've chosen the adventure for you in the policy. But I'll highlight for you as we go through the things that are, where there are options and where you need to check your policy. But always, always, always make sure you're following your policy. Honestly, if everybody in every school division followed their policies, you'd put me and Brad out of business, because that's a large chunk of what we do. So make sure you're checking your policies. And, if you find something here that's vastly different, go back and have that conversation. Now's the time. If you need to update your policies, if you need to update your procedures, the summer is for sure the time to do it before, we get into the next school year. And then after we get through what the process is, we will talk about the extra sort of add-on things you need to do for students with disabilities. Okay, so any discussion about student discipline, and really what I'm talking about from a legal standpoint, discipline is suspensions and expulsions. There's a whole host of other things that might be disciplinary in nature, but you don't need to call the lawyer about if you're not removing the student from school or changing their placement. So when I talk about discipline, that's really what I'm talking about, is out of school, taking the student out of school. So any discussion about removing a student either through a suspension or expulsion, a public school student that is Any such discussion is rooted in the 14th Amendment to the United States Constitution, and that's what we call the Due Process Clause. So, public education is a right, right? Children have a right to attend public schools, so that's a right. And the government cannot take a right away from you without first giving you due process, right? That's the basic concept. So, what is due process? Well, classic lawyer answer, it depends, right? The seminal case, like the main case about due process for students that I'm sure you learned about when you took your school law class, is called VASSP v. Lopez. This was a case back in the 70s decided by the United States Supreme Court, and boiled down to sort of the basics. It stands for the proposition that public school students are entitled to due process before they are deprived of their right to come to school, and the amount of process due depends on what the punishment is. And then in addition to that, a school board can grant additional procedural rights beyond what is required by the 14th Amendment to the United States Constitution. So let me give you a non-school example of what this looks like, okay? So has anybody in the room ever gotten a speeding ticket? If you're brave, raise your hand. I've gotten like a bunch of them. I drive a fast car. Okay, so if you've ever gotten a speeding ticket, now of you who raised your hand, the rest of you, we know you're lying. Those of you who raise your hands, have you ever actually gone to court instead of just paying the ticket? Anybody actually gone to court for your speeding ticket? All right, thank you, honest people. Okay, and all right, so maybe you haven't gotten a speeding ticket. Maybe you have a friend who's gotten a speeding ticket. Maybe the friend went to court. Okay, either way, if you've been, maybe you went with your friend, traffic court, it's a pretty informal process. You don't even get to sit down, right? They call your case. By the time you walk up there, the judge is already asking the officer what you did. The officer just gives a description of what you did, really just reads it off the report. The judge asks you for your, basically what do you have to say for yourself, and then wham, bam, it's over, right? Like that's it. That was your due process. Believe it or not, that's your due process. It's your chance to show up and maybe get a word in edgewise, right? That's your due process. Now, I'm not going to ask this question of the group, but just say, for example, a person was charged with a more serious crime. Let's just use murder because that's like the most serious I can think of. And what's on the line there, we're not talking about, a monetary fine like a traffic ticket. We're talking about life imprisonment, or maybe the death penalty is on the line. Well, you get a whole lot more than you get in traffic court if you're charged with something, a serious crime like that. You get, and I'm not a criminal lawyer, so I don't even know all the ins and outs of if you're charged with murder, but I know you get a pretrial hearing, which is a whole proceeding before the trial. You're entitled to get the government has to give you and your lawyer copies of whatever evidence, exculpatory evidence that they have. You get a hearing, you get a full trial in front of a jury of your peers. There's a lot, you get the point. There's a whole lot more process if what's on the line is life in prison or something like that. So that is also both of those things, showing up in traffic court and the wham bam, what do you have to say for yourself, and everything that happens in a death penalty case, both of those are due process, right? So it's the same, well, it's not the same, but the same concept applies in the school setting. So for a short-term suspension, due process looks different than long-term suspension. It's a little bit more process. And then expulsion, which is sort of the ultimate penalty for a public school student, is even more process. So it's the same concept as the in the criminal context. Okay, so we're going to talk about each one of those. So first, we're going to talk about short-term suspensions. Short-term suspensions, of course, are technically considered something that's 10 days out of school or less. Now, in-school suspension is not a suspension. Due process doesn't attach because we're not removing the student from school. And so what we're talking about here is out-of-school suspension. So 10 school days or less, that's an out-of-school suspension. Under the code, principal, assistant principal, or in their absence, a teacher may actually suspend a student for up to 10 days. The code permits that. Most of your policies also permit that. All right, so what are the requirements for due process? What's the process that's due for a short-term suspension? It's pretty simple. It looks a little bit like traffic court, to be honest with you. The student is entitled to notice. It could be oral or written. And this is short-term only. Once we get to long-term, it has to be written. But for short-term, oral or written notice of the allegations. The code says the charges. That's very formal sounding, but it's really oral notice of the allegations of whatever it is the student did wrong. And then they get a chance to tell their side of the story. So you sit down with the student. I heard that this is what happened. Can you tell me, is that right? What happened, Johnny? Bam, you're done. That's due process for a short-term suspension. Now, if that's all you do and you're trying to expel a student, we're going to end up in court. But that's the due process for a short-term suspension. Now, in some cases, you can even do that due process after you've suspended the student. And that is when the student's presence at school poses a continuing danger to people or property, or when the student's continued presence in school, like right there in that minute, poses an ongoing threat to disruption. You can suspend immediately. You're suspended, go home, and then you can do the notice and a chance for them to say their side of the story afterwards. Now, use this sparingly because really it literally can take a minute to do the due process. You pull the student aside, you have a conversation, and that's the due process. But if you have some sort of serious threat or something going on, or it's the very end of the day and the kid's already on the bus, whatever it is, you can, if you have to, suspend first and follow up with the due process. All right. Now, once you've issued the short-term suspension, which is you've told them what's going on, then you need to follow up with some additional steps. And what those are, and these are really just steps in the code. Once you've had that conversation and given the student a chance to say what they have to say, you've complied with the 14th Amendment. But the code has some additional requirements. You have to follow up in writing. So before it can be oral, but once you've imposed the suspension, the short-term suspension, you have to follow up with a written notice. And the written notice actually has to go to both the parent, student, and with a copy to the division superintendent. And I'll explain why in a minute. That's not a due process requirement. This is going to the superintendent. That's a code requirement. And then the parent has a legal right to request a review of the short-term suspension. And it's either the superintendent or designee who does that review, and that's one of the reasons why you copy the superintendent, because the parent is technically entitled to just go straight to the superintendent and say, I'd like to have you review this. Well, how's the superintendent going to know what they're reviewing unless they knew about the suspension? That's why they get copied on the notice. And then an important thing here to keep in mind when you're talking about a short-term suspension, which principals can impose, it's a review. The superintendent or designee is reviewing. It's not an appeal. Perhaps that's semantics, but semantics matter to lawyers, so in the code, this is called a review. And it's done by the superintendent or designee, and sometimes we call that a hearing officer. We call it a discipline review. We make up fancy names. The code, none of that's in the code. The code just says superintendent or designee. But the parents are entitled to that review, even if it's a one-day out-of-school suspension. So the student's already back in school, the suspension's been served, they are still entitled to that review. And if the superintendent thinks you were wrong and thinks the suspension shouldn't have happened or what have you, they just correct it obviously it's already been served, we can't go back in time, but you take it off the student's record. So they're still entitled to that review even if the time's already passed. And then depending on your policy, the superintendent/designee's decision either is final or is appealable to the school board, just depending on what your policy says. And the one thing here to keep, regardless of what your policy says about appealing to the school board or not, one thing to keep in mind here, because this is just a review, my advice is these are reviews on the record. The parent, unless you have a policy that goes beyond what's required, the parent doesn't have a right to come and have a hearing on this short-term suspension. It's a review on the record, but think about it. If you're the superintendent or the designee, you need enough in the record to do the review. So when you put together your suspension packet, even if it's just a short-term suspension, make sure that you include enough information, details, what have you, so the superintendent, I mean, obviously if you're the one suspending the student, you want the superintendent to uphold that decision usually. Give the superintendent enough, or the designee enough information in that initial suspension that they can uphold and don't need to ask a bunch of additional questions. Because if the superintendent needs to ask you a bunch of questions in order to find out whether to uphold your suspension or not, then it starts to get a little unfair if they're supposed to be reviewing it and they're talking to you, but then they're not also bringing the parent in. So don't put the superintendent in that position. Include that information in whatever in your like short-term suspension, like packet, what have you. Okay, but that's a short-term suspension, and that's the technical requirements. So there's our due process, which is a conversation, and then there's some code requirements for a written notice and a review. Now, there are some additional things you need to know if you're an elementary school principal. 5 or 6 years ago, the General Assembly decided that this was way too simple, and so they complicated it. That's not really what they did. They decided that they didn't want us suspending young students, and so they made it much more difficult to do so. So there's some exceptions, and it gets a little complicated. Just bear with me through this, okay? And actually the slides say K through 3. Really, it's pre-K through 3. You cannot expel pre-K through 3, and you cannot suspend pre-K through 3 for more than 3 school days unless one of these exceptions applies. Okay, everybody tracking with me so far? I see some like shocked and confused looks. Anybody have questions? You're limited for pre-K through 3. We're not expelling and we're not suspending more than 3 days unless, and I'm about to tell you the unless. Yes, ma'am. Correct. So you can suspend for 1 day. The next week they do something else. You can suspend for 2 days. The next week they do something else. You can suspend for 3 days. The next week they do something else. You're still at 3 days. You're still at 3 days. We're not adding them up. Now for special ed students, different story, but you're limited to 3 days out of, man, this microphone's killing me. I apologize. You're not limited to 3 days for the whole year. You're just limited to 3 days basically per incident, unless one of these things applies. And if you have a student where you're doing 3 days, 3 days, 3 days, 3 days, probably one of these applies, or probably you need to start doing something else, right? But in any event, you can go beyond 3 days for pre-K through 3 if you have one of these exceptions. Number one is if the student is convicted or adjudicated delinquent is what they call it for students. I'm just gonna say convicted because that's less words. But if the student is convicted of one of these serious offenses. Now, let me tell you, the likelihood of a 5-year-old getting a criminal adjudication is like 0. I mean, thankfully, I'm not saying that's a bad thing. And besides, the criminal process takes months, if not years, and we're talking about 3-day suspension. So I can't imagine a situation in which you would actually utilize this, because by the time the student has been convicted, so much time has passed, we're way beyond 3 days. So you're almost never going to use this. It's in the code. It's in the code, but there you go. Okay. The next one, also unlikely for this age of students, but maybe, is for possession of controlled substances, imitation controlled substances, and marijuana on school property or at a school-sponsored activity. So we're still not, thankfully, we don't see that a lot in pre-K through 3, but it's possible. If that happens, you could go beyond your 3 days. The next one is, oh, I'm sorry, I missed one on the last slide. Let me go back a second. Nope, wrong way. Yep, I did have it right. There we go. Okay, I'm sorry. So number 1 is adjudicated delinquent. We're never going to use that. Number 2 is if the offense involves possession of a firearm, a destructive device, which that's like explosive bombs, stuff like that, missiles, things like that. So firearms, destructive devices, muffler, firearm silencer on school property. And unfortunately, it's still a rare case, but it's happened. So pre-K through 3, if they have a firearm at school, you could suspend beyond the 3 days or even expel. Okay, so then number 3 was controlled substances. I talked about that. Number 4, I think here's where we're getting into the situations you might see in this population of students. So number 4 is if the offense involves physical harm or a credible threat of physical harm, then you can go beyond your 3 days. There's no strict requirement that you do a threat assessment, but if I'm a parent and you're suspending my student and I don't like it, and you're saying there's a credible threat of a physical harm, if I know half what I'm talking about, I'm going to complain if you haven't done a threat assessment. So you're not technically required, but you probably, and honestly, you're probably doing a threat. If you're doing, you're trying to do the right thing here, you're probably doing a threat assessment anyway. It's not technically required here. We'll get to where it is required in a second. But that's the 4th. So we have convictions, we have firearms, we have controlled substances, and then we have physical harm or credible threat of physical harm. All of those are reasons to go beyond 3 days. And then the 5th one, this is where it gets real complicated. The 5th reason you can go beyond 3 days is if the school board, the superintendent, or the designee find that aggravating circumstances exist. Now, let's put a pin in what is aggravating circumstances for a minute. We'll define it because it comes up again. I don't want to have to define it for you twice. So put a pin in that for a minute. But if you have aggravating circumstances, you can go beyond 3 days. But who can find aggravating circumstances? Look at the slide. Can principals find aggravating circumstances? No. So normally you guys can go up to 10 days, but if you have a student pre-K through 3 and you want to use aggravating circumstances, that's not a call that you're authorized to make unless your policy says the superintendent's designee is the principal. And there are probably other reasons why you wouldn't want that to be the case, but in any event, if you're wanting to use aggravating circumstances, you got to kick it up to central office is basically the answer. Now, if it's firearm, if it's drugs, you as the principal can go beyond the 3 days, okay? But if you want to use, if you look down that list, all 5 of these things, and the only thing that possibly applies is aggravating circumstances, you got to kick it up to central office. And because you can only do the 3 days, you got to have a fast process to get, because if you want to go beyond 3 for aggravating circumstances, somebody's got to make this finding first. So that's got to be a quick process. Fortunately, these don't come up a lot because of the age of the students. Okay, so a couple of tips about this. Like I said, have a process know who makes that determination. If your school board hadn't updated their policies in 8 years, none of this is in your policy, they need to update the policies because they don't say anything about any of this. So make sure you've got this in your policy, make sure you know who's making these determinations. And then, if whatever reason you're using to suspend a pre-K through 3 student beyond 3 days, whatever it is, include that in the letter. We already said you got to send a written notice home to parents if you're going to short-term suspend their student. If it's a grade 3 or lower, include the basis for going beyond 3. It's either conviction, firearms, controlled substances, harm or threat of harm, or aggravating circumstances. Pick one, write it in the letter. All right, that's our short-term suspensions. Again, we'll come back to defining aggravating circumstances in a few minutes, but anybody have questions about short-term suspensions before we move on? Oh, yes. So if the question was, is there an age range associated with that in case we don't have the social promotion, and you might have a 3rd grader who's much older, and the answer is no. The code does not contemplate that. It's grades K through 3. So whatever that student is on paper, they're in grade 3 on paper, then you need to apply the rules for pre-K through 3. That's a good question. Okay, long-term suspensions. Again, 5 or 6 years ago, the General Assembly made some changes that made this more complicated. Long-term suspensions is anything more than 10 days. You're limited to 45 days for all students now. we're not just talking about pre-K through 3. You're limited to 45 days unless one of the exceptions I'm going to tell you about applies. And that's 45 school days. And then beyond, if one of the exceptions applies, then you can go beyond 45 school days and it's still a long-term suspension all the way up to 364 days. So that part hasn't changed. That's been the law for at least the 20 years I've been doing this. So let's talk about the process first, and then we'll talk about what is this list of exceptions. Process for long-term suspension, it's gonna be a little bit more, right, than the process for short-term suspension because the consequences are a little bit higher. So for a long-term suspension, before the suspension, they're required to, and this is right out of the statute, written notice of the proposed action and notice of the right to a hearing. So it's pretty straightforward. One tip here, though, they're entitled to notice of the proposed action, and that means the recommended suspension. And I've always recommended that you include the length of the suspension that you're recommending. I've seen a lot of letters from principals doing the short-term suspension and then saying, and I'm recommending you for a hearing with the superintendent, designee, hearing officer, whatever. That, from my view, doesn't give the parent notice of what the recommendation is. And think about it. If you're a parent and you show up and then your student gets 364-day suspension, you're going to say, oh my gosh, I didn't know that was, if I'd known that was going to happen or a possibility, I'd have brought my lawyer. And then you got to figure out what you're going to do with that. So my recommendation in terms of giving them, complying with due process is give them a specific recommendation. Tell them what your specific recommendation is, and then the superintendent can always reduce it, but tell them in the written notice what that is. And then there's a right to a hearing on a long-term suspension, and you got to look at your policy to figure out who that hearing's with. But that's either school board, committee of the school board, superintendent or designee, and then whatever made-up names we might call those people. That's technically the same thing, but it's at the superintendent's level. All right, so before the long-term suspension, it's a written notice, right? So short-term, we could do a oral notice before, but for long-term, it's a written notice, proposed action, notice of right to a hearing, and who that hearing is with. So you need to, if you have form letters, make sure your form letters comply with your policy. Because you don't want to send a letter, maybe you change school divisions and your old school division was a hearing with the school board and your new school division is a hearing with the superintendent's designee. Well, you don't want to send parents a letter saying they have a right to a hearing with the school board and then it turns out they don't. And they're going to be upset about that. So double check your policy and make sure you're telling people the right thing. All right, then after the hearing, so say the hearing has taken place, and we're going to talk about the mechanics of a hearing in a minute, but after the hearing's taken place and assuming the decision is to long-term suspend, then typically this second notice is going to come from the superintendent or the designee or the school board or whoever conducts the hearing. But they might delegate to you the task of completing this letter, so you ought to know what goes in it. It's another written notice, so you get a written notice before your suspension hearing and you get a written notice after telling the parents length of suspension, information about the availability of available programs, and that could be there are no programs available. It could be we're going to provide you with alternative education. It could be we're going to require you to attend alternative education. It could be there's some alternatives in the community and you got to pay for them. Whatever it is, include the information or say there isn't any. And then you have to include a statement that the student's eligible to return upon expiration of the suspension or eligible to go wherever it is they're going after the suspension. You need to put it in this notice. Again, last point here is if we're going to tell them about some community resources that they could access during their suspension and we're not going to pay for it, be explicit about that in the letter. If you just say, oh, hey, there's these resources in the community and you don't say whether you're going to, who's got to pay for it, they might think that you're going to pay for it. So put that in the letter, sir. Not in the law, so check your policy. And my advice would be do it promptly. Okay, so I said for a long-term suspension, you're limited to to 45 days unless one of these exceptions applies. And unhelpfully, the list of exceptions for this, going beyond 45 days, is similar to the list for K through 3, but not the same. So it's bonus confusing for your long-term suspensions. So number 1 is possession of a firearm, destructive device, pneumatic gun, etc. So if you have firearms, you can go beyond 45 days. Number 2, controlled substances, imitation controlled substances, marijuana. Now, both of those, 1 and 2, firearms and drugs, that's possession on school property or possession at a school-sponsored activity. So if you have an incident where there's a student with a firearm out in the community, you can't use this, okay? You might be able to use something else we're gonna talk about later, but you can't use, they brought a firearm to the family reunion off school property, you can't use that as your reason to go beyond 45 days, okay? They have to bring it to school to go beyond the 45 days. Controlled substances. The third one, this is where it really gets confusing with the other list we went over a minute ago. The third reason you can use to go beyond 45 days is serious bodily injury, okay? Now, if you remember back or flip back, for pre-K through 3, to go beyond 3 days, it was physical harm or credible threat of physical harm. This one is serious bodily injury, so that must be something more than physical harm. There's no definition in the statute. To my knowledge, no appellate court has defined it in a published decision. So be reasonable about what is serious bodily injury. Maybe you have it defined in policy. I think that would be an acceptable thing to do. I would say serious bodily injury is a rule of thumb might be that requires some kind of medical treatment or intervention to differentiate it from just physical harm. I mean, physical harm could be someone got knocked down, in the hall in a fight and got a bruise on their elbow. I'd be okay. I'd defend that that's physical harm, but I wouldn't want to defend that that's serious bodily injury, bruise on your elbow. All right, but that's the third one, is serious bodily injury. And then the fourth one is, this will sound familiar, aggravating circumstances. So if you have aggravating circumstances, you can also go beyond the 45 days. Like our K through 3, aggravating circumstances must be determined by school board, committee, superintendent designee. So that's not a call you're making, that's a recommendation you're making, and then they would make that determination of aggravating circumstances. Okay, so what are these aggravating circumstances that I keep talking about? VDOE has defined aggravating circumstances in yet another confusing list. And get this, aggravating circumstances is just defined in a SUPS memo, in one of the memos issued by the state superintendent. So it could change whenever the state superintendent wants it to change. Now, we're on our third state superintendent since this was defined, and they haven't changed it. So that's nice, because it would be really confusing if they were changing it every time the superintendent changed, or more often. But just know it could change. So currently, and for the last 4 or 5 years, aggravating circumstances has been defined with 3 prongs, really, okay? And this is complicated. I can't make it less complicated because it just is what it is, but 3 prongs. One is that the student engaged in misconduct that caused serious harm. Okay, so now we've got physical harm, we had serious bodily injury, now we have serious harm. None of these are defined, but presumably they each mean something different. And then it goes on to say, including but not limited to physical, emotional, and psychological harm to another person, or if they posed a credible threat of serious harm to another person as determined by a threat assessment. So if you have a student, you want to go beyond 45 days, or you have pre-K through 3 and you want to go beyond 3 days, and you go through my checklist and none of those apply, and you get down to aggravating circumstances, and you're like, oh, all right, it wasn't any of those other things, but I think it's this one. I think it's misconduct that caused serious harm because maybe it's emotional harm. right? Because on our pre-K through 3 list, it had to be physical harm. And before we get to aggravating circumstances, we had serious bodily injury, but say it's an emotional harm. So that's not going to be either of those. So it's an emotional harm. All right, boom, we can use aggravating circumstances. We can go beyond 45 days. Now we've got to do that threat assessment in order to use that prong. It's got to be determined by a threat assessment, okay? All right, so that's one aggravating circumstance. Second aggravating circumstance is the student's presence in the school poses an ongoing and unreasonable risk to the safety of the school, students, staff, others. Really, I think where this comes in, if you're hurting people or people might get hurt, I think you're going to use the first prong. If the threat is to do some harm to the building, maybe, like I'm going to knock down the walls when no one's there, maybe you wouldn't be able to use the other one, right, unless it's harming someone or maybe it's causing psychological harm, I don't know. But if the threat is just to the physical plant of the building, none of the other exceptions probably apply. You could use number 2 on this one, okay? And then the third aggravating circumstance is this is kind of the one where if the offenses really aren't rising to the level of being really severe, but it's that student you were asking me about earlier who it's pre-K through 3, but we've done a day, we've done 2 days, we've done 3 days, we've done 3 days. It's nothing like really egregious, but we keep doing the 3 days. Can we go beyond the 3 days? Maybe under this last prong, if the student engaged in a serious offense that's persistent, it has to be documented as persistent, and has been unresponsive to targeted interventions that have been documented through the process, right? So we've been working with a student, they just keep doing this kind of serious offense, but not super, we're not hurting anybody. You could get beyond your 3 days, or for an older student, beyond the 45 days if you follow those steps. I know that's dense, it's complicated, it's just the way the law is. And honestly, when you guys call me or your superintendents call me with a discipline question, I literally pull out the last presentation I gave on this and I go through the bullets until I find the one that applies, or I'm like, no, none of these apply, because it's just too complicated to have it all memorized at every level of student. So if it seems like a lot, that's because it is, honestly. Okay, so we've talked about short term, talked about long term, now we're gonna talk about expulsions. Obviously, well, maybe it's not obvious, but expulsions are a removal for 365 days or more. And my tip on this one is don't say expulsion for 365. Like, if I could stop everyone from saying expulsion, like that's my mission right now, is to stop people from saying expulsion for 365. Like, because it's unnecessary. It's like saying ATM machine, which I say, so it's okay, I'm not criticizing you, but you know the M in ATM is machine, right? So you don't really need to say ATM machine, but I say it. Expulsion is like you don't need to say for 365, because expulsion means expelled, which means you're out of school forever unless and until we let you come back. And as we're going to see in a second here, and like I said earlier, expulsion is the most serious consequence we can issue for a student, so they get the most process, right? So we got to go through more. We got to jump through more hoops to do an expulsion. Well, if you're gonna expel for 365, you're getting one more day than 364. You're getting one more day, and that's a whole lot of extra work for one more day. Just expel, period. You're expelled, period. That's okay. You're allowed to say that. I recommend that you say that. I'm not recommending that you go and expel kids, but if expulsion is necessary, expel, period. Don't add days to it. Do add days when you say, I'm recommending a long-term suspension, tell them the days for 364 days, for 75 days, for 45 days, whatever. But if you're saying expulsion, period, don't add days. Okay. And for pre-K through 3, you cannot expel unless one of those exceptions applies, right? You have to find one of the pre-K through 3 exceptions if you're going to expel a student in those grades. Beyond 3rd grade, 4th through 12th, you're limited on your long-term suspension to 45 days unless one of those exceptions applies, but you can still expel even if you don't have an exception that applies. I don't think that that was really what was intended by the General Assembly, but that's the way the law was written. But for pre-K through 3, you have to find one of those reasons if you're going to recommend expulsion. Okay, so for an expulsion, we'll talk about, well, first of all, the process for an expulsion is written notice, and they're entitled to a hearing, and on expulsion, they're entitled to a hearing with the school board or a committee of the board. So a superintendent, a designee cannot expel. You can't even have a policy that allows the superintendent to expel. They can recommend expulsion and they can long-term suspend, but they can't expel. Only the board or a committee of the board can expel, okay? And there's a list of things. I'm not going to go over all these in the code. You can read the slide. There's a list of things that the school board has to consider for an expulsion. Firearms and weapons are different, but any other expulsion, the school board has to consider all this list of things up here on the slide. So when you're putting together your discipline packet, or when you're helping the hearing officer or whoever put together the discipline packet, if the school board has to consider these things, let's put these things in the discipline packet because they're required by statute to consider them. So use that as a guide. Now, because school board lawyers are involved in advocating and helping the General Assembly pass laws, there's also helpfully an exception in the law that says if the school board forgets to consider one of these things, it's not grounds for reversal, but still you don't want to be the principal that set your school board up for people to complain about it. So you want to make sure that all those factors are presented in the hearing. And then the notice requirements before expulsion, they're entitled to written notice of the proposed action. And all right, if you're recommending expulsion, what's your recommendation? Did somebody just say 365? Your recommendation is expulsion. I regret to inform you that I'm recommending your student, Joe Smith, be expelled, period. No days. Okay, and then you have to give them notice of the right to hearing. And then after the hearing, the notice requirements, notice of the length of the expulsion, expelled, period. I regret to inform you that the school board voted to expel your child, period. Now, if the board votes to expel for 365, then on the 366th day, the student's back in school. If the board just votes to expel, then they can petition for readmission, but readmission's not guaranteed. And 9 times out of 10, that doesn't matter, but sometimes it does if the student has been, if they've been out for a year and they've been committing crimes and doing all kinds of heinous things. If you expelled for 365, then on the 366th day, they are back in class. Nothing you can do about it, unless they're in custody, in which case they can't come, but otherwise they're back. So you want to expel, period, and then that gives either the board or someone a chance to take a look and decide whether to readmit the student or not. That's really why I get on the soapbox about that 365. And then same thing, I won't repeat this, but same thing for the notice, everything about what's available, alt ed, all that's the same as in long-term suspension. All right, and then, like I said, you're actually required by law, your school board's required by law to have a policy for readmission, and it should be timed so that they apply for readmission, and if it's granted, they're back on the 366th day, and if it's denied, then they're still expelled. Again, here you just want to know your policy. You can either have that decision to readmit made by the school board or made by the superintendent or designee. Either way, just make sure you're following your policy. Firearms and weapons are a little different, keeping with the theme of making it confusing. State law says for firearm, and this is really, it's because of federal law for guns and drugs. So federal law requires these provisions. So what the law says is for firearms, the student must be expelled, except you don't really have to expel them. So you can find special circumstances and then not expel. But if you're in a school division where it's commonplace, like everybody's like, it's an automatic recommendation for expulsion, that's why, because the statute says that it is, unless you find special circumstances. Same thing for drugs, basically, controlled substances. This is based on, again, federal law from, it's like the, from the probably early aughts, maybe 90s, era of federal law. But basically, again, supposed to be a mandatory expulsion, but then we sort of backed off of that. But instead of taking it out of the law, we say it's mandatory expulsion unless we find special circumstances. So again, be guided by your school board policy, and sort of policy as in written policy, but also be guided by your, the policy with a lowercase p in terms of how drug cases are handled in your school division. And then just a note here, you should also have policies that are broader, right? So what the law deals with is firearms. But there's lots of things that are weapons that aren't firearms that you probably want to be able to discipline students for if they bring them to school. So your weapons policy should be broader, and probably your drug policy should be broader too, because law just covers controlled substances, imitation controlled substances, and marijuana. But what if kids are bringing, what if they're bringing their Tylenol or what have you and passing it around? If you want to have some say about that, you need to have it in your policy. And then the last thing under sort of regular ed I want to talk about real quick is just alt ed. It's not used as often, but maybe it should be, is the code allows for placement in alt ed without even a suspension or expulsion. You can just require a student to go to alt ed if you give notice and opportunity for a hearing. Now, there's certain circumstances, but this fits a wide variety of circumstances. One is if they're charged with certain offenses. So this is where maybe a student brings a weapon to their family reunion. You can't suspend or expel for that, but if they're charged for it, you can require them to attend alt ed. And then ultimately, if they get convicted or found not innocent of one of those offenses, you can continue and you have to give them notice in a hearing, but you can require them to attend alt ed without ever suspending or expelling them. That's 2. 3 is if they've committed a serious offense or repeated offenses in violation of school board policies or your code of conduct. So maybe it's not a crime, maybe it doesn't rise to the level of a long-term suspension or expulsion. You can still require a student to attend an alternative placement in lieu of a suspension under this code section. The process for this, again, be guided by your policy because there's some different options, but it's basically written notice and opportunity for a hearing with whoever your policy says. School board, superintendent, designee. All right, so that's sort of the legal process, all the different boxes you have to tick. Now I want to talk a little bit about the actual discipline hearings. So we're going to talk about a couple of things before, a couple of things during, and a couple of things after that you as a principal can and should do, or maybe assist your hearing officer or whomever with doing. All right, so before the hearings, you want to make sure you've complied with the notice requirements. We've already talked about what those are, so you can go back, whichever short-term, long-term expulsion, you can go back and see what those notice requirements are, and make sure your notice is sufficiently detailed. One of the things, and I get a lot of surprised looks when I say this sometimes, but one of the things I recommend you do is, and this goes back to the fundamental due process, people are entitled to a notice of what they're charged with doing, notice of what they've done wrong. Don't just use the offense codes, right? So say you're a parent and you don't know what any of this means, and you get a letter saying your child is charged with a violation of code EFG1. I don't know what that means, right? So it's fine to include the code because it makes reporting easier down the road. I get that, but actually include a description with words in plain English of what the student actually did. So I have some examples. And it's fine to say controlled substance, but then, include those details of the student brought 5 pink pills and said it was Ritalin. Then the parent can't complain about, I came to this hearing and I didn't know what this was about. If you put it in the letter, then they can't claim that they didn't know what it was about, and they can't, at least not successfully claim that they didn't get due process. So be specific. I got some more examples. I won't read all these to you. The point is include the details. And I say don't say. It's fine. You can say that. Don't just say assault and battery. You could say assault and battery, student struck the teacher in the arm with his fist. But, assault and battery could be a lot of things, right? Assault and battery, Could be punching someone in the eye, it could be poking someone in the arm. Both of those are assault and battery technically, but one's more serious than the other. So include the details, that's the point of this slide. Okay, moving on from what you put in the notice. Before the hearing, and really if we're having a hearing, we're really talking about a long-term or an expulsion, because for short-term it's just a conversation. So when you have a hearing, prepare. Take a few minutes, take whatever time you need, but be prepared. Give the superintendent or give the school board or give your hearing officer, whatever you call them, give them everything they need so that they can make a decision in your favor, right? If I'm representing you in a lawsuit and we're gonna go to court, I'm gonna prepare and I'm gonna package everything up and I'm gonna give the judge everything the judge needs so that he can decide in your favor. It's really no different. Maybe a little less rules and a little less formal, but prepare so that the board or the superintendent can support your recommendation. Don't rely on your memory. Now, I get some superintendents are like, Stacy, stop telling my principals this. So take this with a grain of salt, but after sitting through 1,000 discipline hearings in my career, please don't just read the discipline report. Now, if your superintendent tells you to read the discipline report, then do what your boss tells you to do. But if they don't tell you have to do that, I say summarize it and then be prepared to answer questions, be prepared to elaborate. If they want you to read it, that's fine, but also be prepared to answer questions and elaborate. If you just read it and then they ask you a question and you're not able to answer it, that's also not very helpful. So be prepared to discuss and explain the case. During the hearing, this may not be your job, but you can make sure someone in the room is doing it. Create a record of the hearing. I like to either do an audio recording, or I've had school boards that I've represented for years that for every expulsion case, they had a court reporter come and take everything down. The reason you want to have a record, even if it's just an audio recording, is that if the parents seek judicial review, and there is a mechanism to seek review in court, if I'm your lawyer, I'm going to argue that all the judge should consider is what was presented. That's really getting me. I'm sorry. Apparently I talk with my hands a lot more than I realized. If this gets to court, I'm going to argue that the judge should only consider what the school board considered. And we can give them the recording, or we can give them the transcript and the documents, and that's it. We're not going to call witnesses. We're not going to retry the whole matter in court. But if we don't have a record of what was presented to the school board, it opens it up for the parent's lawyer to say, no, we should bring witnesses. I'm going to bring 15 people who didn't come to the school board's hearing, and we're going to spend all day and all week and run up attorney's fees to hear from all these people. So that's really the reason I say to record it. So have some mechanism of making a recording of what happens at the hearing, and then make sure you preserve the documents. So afterwards, if you got to call the lawyer, I'm going to ask for everything that was presented at the hearing. So you need to have whatever administration presented, and you need to have whatever the parents showed up and wanted to have presented. And so if they show up and they want you to, they bring 700 pages of whatever, thank you very much, and put it in the record, right? And then, present the case, be prepared during the hearing to present the case in a coherent fashion. Be specific, include as many details as you can, and then present any relevant documents, evidence, videos, statements, whatever. Give the superintendent or the school board, whoever's hearing the case, copies of everything you want them to consider. And also this, the parent or student is entitled to anything that you use to support your case. So there's no secret documents. There's no secret video that the parents aren't entitled to see. If you're using it to support your case, they're entitled to it, right? Let's think about due process. Let's put ourselves back in criminal court for a minute. If the prosecutor has some video that they want the judge or the jury to see, of course, the criminal defendant and their lawyer are entitled to that, right? Like we don't let the prosecutor go back with the judge after the fact and be like, okay, now that other pesky defense lawyer's not in the room, let me tell you all the good stuff. No. And so that's another thing. When I see it a lot, the Principal presents the case, the parent and the student are there, they say whatever they say, and then they leave the room, and then the school board or the superintendent or whoever is like, okay, Mr. Principal, now that they've left, tell me what you really think. You shouldn't be doing that. That's not consistent with due process because, again, it's akin to the prosecutor going back in chambers with the judge after the hearing and telling the judge all the good details that he didn't share with the other side. So you really should make sure that you're presenting everything you want the board or whoever's providing the hearing to consider while the parents are in the room. They get to hear it and they get to respond to it. Otherwise, you risk, you really are risking legal exposure. Okay, I'm going to say another controversial thing here. So if you've fallen asleep, pay attention here. Wake up your neighbor. So usually the facts aren't in dispute. The student admits whatever they did, and so it's pretty straightforward, right? And you can just present it and you can say the student admitted it. And that's okay, and that's consistent with due process. The rules of evidence don't apply. You can have hearsay, you can have third hand, whatever, that's all okay because these are administrative hearings. In fact, I get really bad habits go into these hearings because then I can't show up in court and do the same thing because, the rules of evidence apply in court, right? When hearsay is just in court, it's an out-of-court statement. So it would be a statement made outside of the hearing that you're presenting. So it would be if you present the case and you say, well, so-and-so classmate told me X, Y, and Z. That's hearsay because that classmate isn't here to stand for cross-examination. So that's hearsay. Now, Johnny, who's accused and who's here in the hearing, I'm going to tell you what he told me too. That's not hearsay because Johnny's there and he can be cross-examined about it. He can deny it or whatever. So that's hearsay. And that's okay. You can have hearsay because these are administrative hearings. The rules of evidence don't apply. So you can have hearsay. The rub is that to be consistent with due process, a suspension or expulsion shouldn't be based solely on hearsay evidence, okay? So if the student admitted it, that's not hearsay, you're good to go. If the student denies it, technically, you need to have some competent non-hearsay evidence of whatever the offense was. If an adult witnessed it, bring that adult in, have them testify to what they saw. That's easy, you comply with due process. Okay, question is it okay to have a student write a statement? Absolutely, and it's okay to present that, but it's hearsay if that student's not, if we're talking about a third-party student, a witness. Oh, yes, absolutely. Yes, that's totally fine, and you can use that. Now, I'm going to suggest that you go beyond that and ask that student hard questions. I mean, if they write it down, yeah, so absolutely. If you can get a student to write it down and put their name on it, whatever, excellent. I just don't like to rely solely on okay, hey, write your statement and give it to me. 9 times out of 10, you're gonna get back garbage, right? But if you interview the student and they answer questions, have them write it down, or you can even, you're gonna do this for every little infraction, but if it's something more serious and you interview the student and they admit it and they give you details, if they have them write it down or you write it down. Hey, I'm taking some notes here. I'm gonna go print it, let you read it. If you wanna make any corrections, you let me know. We'll do that as many times as we have to. Once we get it the way you like it, you sign it for me, okay? That's an investigative technique I would recommend for any investigation, even beyond sort of student discipline, is to have them write it. Okay. So, back to hearsay. So, technically, to comply with due process, you shouldn't be relying solely on hearsay evidence. If the kid admits it, it's not hearsay. If you have an adult witness who comes and tells what they saw, and then you can add all the other additional hearsay you want as long as you have one eyewitness. If you have a student witness, you could bring another student in to testify. And I will tell you that's how you comply with due process. Now, people get squirrely about that, and I understand. And look, do we have cases where we suspend or expel students based completely on hearsay evidence? All the time. Do we get away with it? Most of the time. Just know that if you don't have any non-hearsay evidence, it's all third hand and we're not bringing those students or whomever in to testify, that student gets an attorney and that attorney challenges you and says, this is a violation of due process because it's all hearsay, they're not wrong, okay? So I have had cases where it's a serious infraction and the superintendent didn't want to risk being overturned. We brought in students to testify against other students. Nobody likes doing that. Nobody wants to do that. And I'm not, good Lord, I'm so sorry. I'm not saying you have to do that in every single case, but there could come a time where you need to bring in student witnesses and you'll just have to make the call. And maybe the decision is, I would rather risk it than put these students through that. That's fine. My job is to just let you know what the risks are. Like, you guys get to decide if you're gonna speed on your way home tonight, right? I'm just gonna, we're just gonna tell you what the speed limit is and then you get to decide. Same thing, right? Okay. All right, after the hearing, a few more tips. There's notices that go out after every hearing. If the student is long-term suspended or expelled, you know what those requirements are. If the student's not long-term suspended or expelled, there's no legal requirements, but you should probably follow up and let them know that they're not going to be long-term suspended or expelled. Be specific and precise in these notices. Make sure you preserve the record. So, if you hand out copies of the packet, normally we try to get those back so that they're not walking around on the street, but make sure somebody keeps a copy and make sure somebody keeps a copy of whatever the parents brought, and put that in the file in case it goes forward. And then include copies of all those notices just in the record, and that way it's all there in case they appeal to the next level or in case they go to court. Okay, so that's the big picture process. Sort of, we put a pin in students with disabilities. So now we're going to talk about students with disabilities. And look, this is by no means a soup to nuts presentation on anything about students with disabilities. I could fill an hour and a half or 5 hours about that. That's not the purpose today. The purpose today, the focus on discipline. I'm just going to hit a few requirements and that you need to just keep in mind when you're talking about your students with disabilities. So there's a couple of big picture concepts we're going to talk about. We're going to talk about short-term removal and long-term removal. We're going to talk quickly about manifestation determination reviews. We're going to talk super quick about functional behavioral assessments and behavior intervention plans. We'll talk about the 45-day removal, but just real quick. And then we'll talk, again, like one slide about protections for students who have not yet been identified, but are maybe in the process of being identified as eligible for special education. Okay, so short-term removals, and here, the reason we're going to spend a little bit of time talking about a short-term removal and a long-term removal is you need to know which you're under, because once you get to a long-term removal, you've got to do an MDR. So that's why it matters, okay? So a short-term removal is 10 consecutive school days or less. That one's easy. But it's also once a student has received 10 cumulative days, so not consecutive, but it's a day here, a day there, a day here, a day there. Once you get to 10, then any more days, so even just one more day, it is permissible as long as it's not a pattern. So once you get to 10 days in a year, you need to do a pattern analysis, and we'll talk about what a pattern analysis is in a minute. And then for your removal of up to 10 days, you're not required to provide services. So say beginning of the school year, student engages in an infraction and gets 10 days. That one's easy. That's a short-term removal, and you're not required to provide services. Nor are you required to provide services if you get, a day here, and you get to day 11, you need to do the pattern analysis. You're not necessarily required to provide services, but you need to make a determination of the extent to which services are necessary for the student to continue participating in the general education curriculum and to continue progressing towards IEP goals. So there may be circumstances where you don't have to provide services beyond 10 days. In most cases, out of abundance of caution, we typically are. Now, So I said 10 days, right? What's a day? What's a day of removal? A couple of tricky areas where I see people maybe get in trouble is calling a parent to come and pick up the student, but we don't call it a suspension. First of all, is that a day of removal? Nod your head, yes. Second question, is that a good idea? Shake your head, no. I see OCR complaint. Now, if you want to spend more time with your school board lawyer, if you like me and you found this really fun and you want to spend more time with me, by all means, call parents and tell them to come home. If you like dealing with OCR complaints, by all means, call the parents and tell them to come pick up their kids, because that's where you're going to end up is at best with an OCR complaint. Well, what if we wait till the end of the day, maybe in the afternoon, and call them to pick up the student? It really just depends on basically if the student, it's anything like that where the student is not in class is a removal unless the student is still afforded the opportunity to continue to participate, the student continues to receive their IEP services, and the student continues to participate with their non-disabled peers to the same extent as they would have in their current placement. So basically you can't send a student home and answer yes to those questions. So those count as a day of removal. What about a bus suspension? Does that count as a day of removal? Nod your head yes, unless we've made alternate arrangements to get the student to school. Because in Virginia, we're required to provide transportation. So if a student with a disability has a bus suspension and that results in them not getting to school that day, it's a day of removal and you need to count it just as if they had been suspended. All right, long-term removals. A suspension of more than 10 consecutive days, that one's easy. The tricky part is once you've gotten to more than 10 cumulative days. There was a typo on the slide earlier, so if you have the PDF from earlier, on this slide it says consecutive, and that was because my eyes were crossed by this point. It's 10 cumulative school days. So 10 consecutive school days, or more than 10 consecutive school days, boom, that's long-term. If you're just doing one day here, one day there, once you get to 10 cumulative in the school year, then additional days beyond that are a long-term removal if it's a pattern. So you need to do a pattern analysis. So we're going to talk about that. What's a pattern analysis? Pattern analysis is just where you look at the student's behavior and you, like it says, hence the name, figure out if there's a pattern. You consider whether the child's current behavior is substantially similar to the prior behavior, and you consider the length of each removal, the total time removed, and the proximity. So, I mean, if it's one day 3 years ago and one day this year and then another day next week, that's probably not a pattern, right? Because, again, you're also looking at the school year. But if it's one day in September and then not another day till the end of October and then a few more days in March and you get to 10, that, again, depending on if they're totally different behaviors, it's probably not a pattern. If they're more similar, it's leaning more towards a pattern. Now, who conducts a pattern analysis? It can be done by an administrator in consultation with someone who knows a student, like a teacher, case manager, and it should be done right away. And you should consider discipline records, the IEP. You should review the FBA if you have one. You should review the BIP if you have one. If you don't have an FBA, you should consider doing one. If you get to the point where the student's been out more than 10 days, consider doing an FBA. And then you want to look at the cause of the behavior. So, for example, you want to consider whether behavior was caused by the interaction with certain people, whether it's requirements of a certain task always causes this behavior, or whether it's events that trigger the behavior. You're looking for patterns in all those different places. And so it could be that the incidents themselves don't look similar, but if all the incidents were triggered by the student being asked to do a certain task, then maybe it is a pattern, even if on the surface maybe it looks a little bit different. And then anytime you do this pattern analysis, you want to document it. For our clients, we just created a basic form that asks the same questions that are on this slide, and it can kind of check it. But whatever you use, just make sure you document your decision and the basis for it. And that could, honestly, if you follow one piece of advice out of any of this, it's to document the basis for your decisions. If you do that, you'll save yourself a lot of trouble. Okay, then, so for term removals, so either it was more than 10 days at the get-go, or there's a pattern, and so you've determined it's a pattern, you have to do an MDR. That's manifestation determination review, and you need to do it no later than 10 school days after the determination is made to take action. And on the date that the decision is made to recommend long-term removal, you also have to provide parents a copy of the procedural safeguards. So for your students with disabilities, that's sort of an additional, we talked about all the notice requirements earlier. When it's a student with a disability, add procedural safeguards to those notices. Again, I could do a 2-hour training on MDRs, so we're just barely scratching the surface on MDRs. Okay, so there's certain questions that you gotta ask when you do the manifestation determination review. There's normally a form, the questions are on the form. I'm not gonna belabor the point here. Pay attention to those questions, right? Look at the questions, look at them carefully, and I mean, I'm not gonna tell you that certain behavior is never a manifestation or certain behavior is always a manifestation, because it's always a case-by-case, individualized determination based on that student and their behavior and their disability. Read the questions carefully and pay attention. If you find yourself determining that misbehavior is a manifestation of the disability, read those questions carefully and make sure you're sure that that's the determination, that's the correct determination. And then in terms of who participates in the MDR, it looks a lot like the IEP team. It's an administrator, a parent, a regular ed teacher, relevant members of the student's IEP team as determined by the parent and the school division. If the parent wants to bring somebody else, generally I say let them, unless it's causing a real problem. And then make sure the team has all the relevant information to review student's file, IEP, any observations, any data, consider anything that the parent wants you to consider, bring that. And you want to make sure you're considering all those environmental factors, program, home factors, students' mental health, basically a full picture. Now, if you answer all those questions in the affirmative and you determine that it is a manifestation of the student's disability, then the student's back in school. We can't do a long-term removal. Unless the exception to that is if the 45-day removal applies, and we'll talk about that in a minute. But otherwise, the student's back in school, and we're not doing a long-term removal if it is a manifestation. Now, if it is a manifestation, you need to do an FBA and implement a behavior intervention plan, or you already have those in place, hopefully you do. You should revisit them because clearly maybe something needs to be changed or updated, so revisit them, and then also consider whether revisions to the IEP are also appropriate given to address these behaviors, or possibly even address placement if you've determined that maybe placement's not appropriate anymore. And then keep in mind, you can consider other disciplinary measures that aren't a removal. If there is a manifestation, you can't remove, but you could do some other things that aren't a removal as long as it's not affecting FAPE and it's not a change in placement. Could be loss of privileges, that kind of thing. All right, and then if the conduct is not a manifestation, so no manifestation, then you proceed and you discipline just like you would a regular ed student or a non-disabled student, the only difference being the student is still entitled to get services which are determined by the IEP team during the course of the suspension or expulsion. But that's the way you change the placement, is you find it's not a manifestation and you proceed with your suspension or expulsion. Okay, I talked about 45-day removal, or I mentioned it. I'm just gonna real quick. Student with a disability, you may, if you're not able to suspend or expel, you may place the student in an alternative educational setting for 45 school days. You're limited to 45 school days if weapons, drugs, or serious bodily injury. So you're limited. And if your conduct is a manifestation and it doesn't involve weapons, drugs, or serious bodily injury, can't change placement. Can't do the long-term suspension or expulsion. All right, and then just a quick word, again, this could be the subject of an entire day of presentations, but just a quick word. For a student who's not yet eligible for special education related services, they can assert the same protections as a student who is eligible if the school division has knowledge that the student has a disability. So be careful here, and obviously it depends on a lot of factors here. There's a lot of moving parts, but just know if a parent comes forward and says and challenges the discipline, just know you need to look through this next checklist, which is school division has knowledge when a parent has expressed concern. It does have to be in writing, and has to go to the appropriate either administrator or teacher. This parents express concern in writing the student has a disability, needs services. The parent has requested an evaluation, or the teacher or other school staff basically has expressed concerns about the child's behavior and indicated that they may be in need of special education services to, again, it has to be the appropriate people. You can read the checklist. So in those three circumstances, the student is eligible to protections like a student who's been identified. But if the parent has refused permission to evaluate, then you're not deemed to have knowledge of a disability and they're not entitled to those protections. All right, and then I said I had a bonus topic if we had time. I'm not sure we have time, so I'm just going to put the slide up here. Fourth Amendment search and seizures. Searches have to be reasonable at their inception, which means at the time you conduct a search, it has to be reasonable. And then the search has to be reasonable in its scope, which means based on the circumstances, is the search reasonable? Quick example, if you have information that a student has contraband, say it's a THC vape, and it's reported that the student hid the THC vape in their backpack. If that's if that comes from a credible source, it's probably reasonable to search the backpack. It's reasonable at its inception, reasonable in scope, just looking in the backpack. Probably not reasonable in scope to strip search the child, right? Because no one told you that the student was hiding a THC vape in their underwear. And so you wouldn't do, and there's actually a case, it wasn't a THC vape because it's like a couple decades old, but it was, I think, cigarettes or something. But the point is, it has to be reasonable based on the information you have. So a search of the backpack would be reasonable. If the information was that it was in their pocket, asking them to turn out their pockets would be reasonable. I would advise, you should get someone else involved and maybe call counsel before you ever